Good afternoon, everyone. I'm just going to just wait for a few seconds, if that's all right, just to see if there are a few more joiners, and then we'll start. Okay, well, welcome everyone to today's Housing Snapshot. My name's Simon Murphy, and I'm a partner in the housing management team. And I'm joined today by my colleague Bill Trow, who is a senior associate in the housing management team. Forfeiture, giving tactics and tips where there is non-payment of rent, service charges, no contact from tenants, and or the tenant has died. So a not very jolly subject, I'm afraid, for a Monday in January. But let's start by looking at the fundamentals of forfeiture. Firstly, to forfeiture clause. If there is no written lease, or there is a written lease with no forfeiture clause, you're going to really struggle to use this remedy. Secondly, you need to consider what the breach is that you want to forfeit for. Is it non-payment of rent, or is it something else, like failure to repair or sharing occupation without? If you're only forfeiting for non-payment of rent, you don't need to serve a pre-forfeiture warning notice, which is called a Section 146 notice. You can simply forfeit by issuing proceedings. If you're forfeiting for a combination of rent arrears and another breach, or just for a non-6 notice, you will need to allow a reasonable time for the breach to be remedied if it is capable of remedy before forfeiting the lease. As most of you will be dealing with houses and flats rather than commercial properties, you have no choice but to forfeit by issuing proceedings. And when you do forfeit by issuing proceedings, the service of the forfeiture proceedings is technically the act of forfeiture, but the landlord is not entitled to enforce its right to possession prior to the trial of the matter. Instead, the tenant can bring an action for breach of covenant by the landlord and can enforce compliance with the landlord's obligations under the lease, even though things. Okay, moving on to waiver. What is waiver? Well, waiver occurs where a landlord has knowledge of a tenant's breach and performs an unequivocal act which recognises the lease as continuing to exist, and it communicates that act to the tenant. Waiver is unfortunately really easy to achieve if you're a landlord, so you need to be really careful. For example, if you send out a demand for future rent or a demand for future service charges, that will waive the right to forfeit. Where a tenant has assigned or sublet without consent, asking for details of the subtenant and therefore prejudice basis will waive the right to forfeit. So you just need to be really careful and get legal advice if you want to go down this route. Okay, moving on to wrongful forfeiture. Wrongful forfeiture is where a landlord attempts to forfeit a lease when there has been no breach of covenant. And that's probably best illustrated by a case. It's the Ruby Triangle Properties and Jesus Sanctuary Ministries case that I've put on the slide. This case provided that where a landlord changes the locks and it's later found that the landlord was not entitled to do that. And don't forget, you can't change the locks on residential properties. You need a court order, i.e. damages which are over and above any losses the tenant has incurred. And in that case, the aggravated damages were 3 months' rent. The case also highlighted the risks of changing the locks personally without using bailiffs. The church, who was the tenant, accused the landlord of stealing cash in the pastor's office amounting to nearly sound that the pastor was an unreliable witness, so the case was not proved. But nevertheless, the case highlights that it's a high-risk strategy to forfeit a lease yourself without using bailiffs. If bailiffs had been instructed, the conversion claim would have been covered by the bailiff's insurance and wouldn't have. The other thing that we need to think about with forfeiture is relief from forfeiture. So relief from forfeiture is the returning of the leasehold interest back to the tenant despite the breach of covenant, but usually on the basis that the breach has or can be made good and on payment of the landlord's reasonable costs. Parties like banks can seek relief from forfeiture, but it's a discretionary, equitable remedy. The tenant must apply to court for relief, and the tenant should remedy its breaches prior to getting relief. As it's a discretionary remedy, tenants should be aware that it's only available if the court considers it just and equitable to grant relief. Okay, so how does this work in practice? Well, I just wanted to conclude by giving an example of where I've recently advised a social landlord on forfeiture and possession in what was a slightly unusual case. The tenant held a long lease from my client under which they had staircased to 100% of the lease amounts. The tenant had paid off the mortgage, so there was no bank who could help. The tenant hadn't paid her service charges for the last 24 months and had run up arrears of a few £1,000s. My client sent letter after letter, made numerous telephone calls, and knocked on the door a few times. My client was aware that from the neighbours that the tenant was still living there and seemed to be in good health and to have capacity. My client was happy to help if the tenant would get in touch. My client would consider reverse staircasing if that would help the tenant to pay off the service charge arrears. Service charges were reserved as rent under the lease. So there was no need to serve it. We advised that we should send the tenant a pre-action protocol letter explaining that if they continued to ignore our client, we would have no option but to issue possession proceedings. We also served a Section 8 notice specifying grounds 10 and 11, as our client had signed up to the code preventing social landlords using mandatory ground 8. Finally, at the same time, we were once again requesting the tenant to get in touch and explaining that if they did get in touch, we might be able to explore ways of paying off the service charge arrears in a reasonable way. The tenant did get in touch, so the letters worked, but before making any offers, the tenant disappeared from contact again. So the client was left with no alternative, but happily the tenant did turn up at the hearing, and so a suspended possession order was granted, plus costs. Our client was incredibly frustrated that they needed to jump through so many hoops when all they really wanted was for the tenant to get in to pay off the service charge arrears. But that the court intervention did help, and now the tenant has a gun to her head, forcing her to pay off the arrears. Otherwise, the possession order can go ahead. Okay, that's all for my section. I'm going to hand you over to Bill, who is going to think about the situation where a long leaseholder dies and give you further advice in relation to possession and forfeiture. Thanks, Bill.
Sorry, that's embarrassing. 3 years after the pandemic, and I've still not learned to unmute myself. So thanks, Simon. So yeah, I'm looking at forfeiture, but also the procedure under Section 8 of the Housing Act 1988, and then some examples of issues facing social housing landlords. The first thing to consider when you're looking at terminating a shared ownership lease is whether you can use the forfeiture method, which Simon's just been talking about, or whether you need to be serving notices under the Housing Act 1988. This is because lots of shared ownership leases will be assured short-hold tenancies, despite not necessarily being described that way on the lease itself. So things to look out for include the level of the rent the tenant's paying. So no rent will mean it's not an AST, or a very low rent similarly may mean that it's not an AST. Tenants must be in occupation of the premises as their only principal home. So if they're subletting, for instance, that lease will no longer be an AST. But if it is covered by the Housing Act and is an AST, then the termination process in the Housing Act 1988 needs to be followed in conjunction with the forfeiture procedure. So what is that process? It's very similar to the Section 8 process normally used when terminating an AST. There are 17 grounds set out in the Housing Act which a landlord can rely on to terminate a lease. However, as Simon's mentioned, be careful, because one of those is commonly not used by social housing landlords, and that's ground 8. That ground is used where a tenant is in 2 months arrears or more when notices are served, and those arrears are continuing at the date of the possession hearing. And that's a mandatory ground, meaning the court has to grant a possession order if those conditions are met. But as I say, many social housing, shared ownership leases, specifically prevent social housing landlords using that ground to seek possession. So this means you may end up relying on other non-payment of rent grounds, 10 and 11, but those are discretionary. So there is a significant chance that the court will refuse to make a possession order, even where there are still outstanding arrears for the date of the hearing. And even if you could rely on ground 8, if the tenant has borrowed money to finance their purchase of the property, then the lender will almost certainly need to be informed about the arrears and about the steps you are planning to take to seek possession before you start that process. There's normally a covenant in the lease requiring the social housing provider to give that notice to a lender. So what happens when a shared ownership lease is subject to a charge? When you're looking to enforce the terms of a shared ownership lease against a tenant, always check whether the leasehold interest is charged. While the lender will only have security against the tenant's share in the beneficial interest in the property, they do have significant protection against landlords who are looking to terminate shared ownership leases. This is generally in the form of a mortgagee protection clause. So these clauses prevent termination of leases without notice having been given to the lender that the landlord intends to take action. They allow the lender to staircase up to 100% in the event that there's been a breach of the lease, and then to sell the property. They also allow the lender to reduce the sum paid to the landlord to staircase up if the lender has been required to remedy any breach of the lease and that's cost them money. So, for instance, if a tenant is in £10,000 worth of arrears, landlord says to the bank, look, we're going to take action. The bank will generally pay those arrears on behalf of the tenant to stop the landlord being able to repossess and terminate the lease. But then it will staircase up to 100% and look to sell itself. And in that, as a part of that process, the amount paid to the landlord to staircase up will take into account the £10,000 already paid. So the bank is protected in that regard. So if you are looking to terminate a shared ownership lease, which is charged, we recommend that you consider the Council of Mortgage Lenders guidance issued alongside the government, which is available online. It sets out the steps a social housing provider should take when looking to terminate a charged shared ownership lease. It suggests that social housing providers give notice to lenders, work with lenders to assist tenants to pay arrears if possible, or agree voluntary sales or surrenders between lender, tenant and landlord. So I'm just going to talk about some difficult scenarios we've come across involving breaches of shared ownership leases. We've had a case where a social housing tenant had unlawfully sublet their property. So, as I've said, importantly, this means that the shared ownership lease wasn't an AST because the tenant wasn't occupying it as their principal residence. In this case, similar to Simon's case, the tenant just wasn't responding to us. So we had to take the decision to begin the process of terminating the lease. And as the lease wasn't an AST, we had to use the forfeiture process that Simon's described, rather than the Section 8 process. We also had to be particularly careful not to waive the right to forfeit by continuing to demand rent. And so we served a Section 146 notice setting out what the breach was, and we also sent a copy to the bank because the leasehold interest was charged. And at that point, the lender made contact with the tenant and luckily was more successful than us in persuading the tenant to stop subletting. Sometimes tenants can be a little bit more scared by the lender than they can by their landlord. So you may also find that you have issues with properties falling into significant disrepair. So taking an example here where the lease was an AST, this required us to serve a Section 8 notice on the tenant specifying the grounds we were seeking to terminate the lease on. But again, if there was a lender, we would have let them know, but there wasn't in this case. So we specified the correct grounds, but we also tried to work with the tenant in this case to remedy the breach. On the basis that the disrepair grounds under Section 8 are discretionary. So you have to try and show the court that you've done everything you can to be reasonable. We did that, but we still had issues with the tenant, again, not being responsive, not taking action to remedy the disrepair. And in the end, we decided that injunctive proceedings rather than possession proceedings were the best way to go. They can be more effective in that the court is happier sometimes to grant injunctive relief than to terminate a tenant's lease. And finally, problems can be encountered where a tenant has died, particularly if they've died intestate, which means they've not made a will, or if they have no living relatives. If a tenant hasn't left a will, their interest will initially vest in the public trustee until someone obtains legal authority to deal with the estate. Where there's no will, legal authority is obtained by the grant of letters of administration, which need to be applied for. If no one's interested in administering the deceased tenant's estate, it is highly likely that unless action is taken, significant arrears can build up. This is because the lease will continue despite the tenant's death. If no one is appointed to administer the deceased's estate and the landlord does want to terminate, notices must be served in the usual way, but they must be served at the property, but also on the public trustee. And at least in this way, this gives any interested parties notice that the lease is about to be terminated and that the deceased tenant's equity will be lost. Even if someone is appointed to administer the estate, this can cause problems. I'm currently assisting a client with a case where, despite the appointment of an administrator, who's been responsible for the estate for some time, the leasehold interest has still not been dealt with. This has resulted in a build-up of arrears together with administrators' fees and other costs. Unfortunately, all of these costs make a sale of the property at market value untenable, as there will be significant shortfall when the property is sold. But in this case, as the property is charged to a lender, we've decided the least bad option for the client is to inform the lender, who's going to pay the arrears, and then we expect will deal with recovering possession and selling the property. So the takeaway really is that termination of a shared ownership lease is a tool which can be used in certain circumstances. We appreciate there will be lots of internal and external pressure not to be seen to be terminating social housing tenants' leases, and that definitely should be the starting point. So efforts should be made to work with the tenant to resolve issues. But if those aren't working, threatening to or actually taking steps to terminate a lease can often get you where you need to be. And particularly if there's a lender, because they will be keen to avoid losing their security. So that's everything from me, and I hope this has been useful. And if you're ever considering terminating a shared ownership lease, we'd obviously be very happy to speak to you about your options. And please do let us know if you've got any questions following this talk.
Hi, Bill. There's just one question. And if you serve a Section 8 notice specifying grounds 10 and 11, do you need to stop collecting rent from the tenant, or can you carry on?
Yeah, that's a good point. It's a tricky one, but technically, the provisions in the Housing Act protect the tenancy until the court has decided whether or not that possession should be awarded to the landlord, and that means the tenancy continues while those proceedings are ongoing. So if you're using the Section 8 process, you can keep demanding rent because the lease is continuing, and so that's very different to the process where you're forfeiting a lease not using the Section 8 process, where you're treating the lease as having stopped, and therefore demanding rent beyond that date will be waiving your right to forfeit. So it's an important distinction between the two. Obviously, if there's ever any doubt, just let us know, and we can help with that.
Great. Thank you very much, Bill. And thank you everyone for attending today. Sorry that the sound quality hasn't always been perfect. Sorry, I can only apologize for that, but we will sort it for the next one. Take care. Bye.
Thanks very much. Bye.